State of Illinois in the Circuit Court of the 17th Judicial Circuit, County of Boone. The people of the State of Illinois, Plaintiff versus Richard O. Wigginton, Defendant. Case No. 2021 CM 81. Sentencing. Report of proceedings electronically recorded before the Honorable Ryan A. Swift, Associate Judge of said court, heard on March 1, 2023 in Courtroom 2. Appearances: Ms. Robin Babcox Poole, Boone County Assistant State's Attorney, appeared on behalf of the state. Mr. James K. Jenks III, Attorney at Law, appeared with defendant. Whereupon, the following proceedings commenced at 1:38 p.m. in Courtroom 2.
All right, this is line 6, People versus Richard Wigginton, who is present in open court with Attorney Jenks. Good afternoon.
Good afternoon, Your Honor.
The state is present by Attorney Babcox Poole. All right. Anything we need to take up prior to decision?
I don't believe so, no.
Okay.
No, Your Honor.
All right. And if the parties want, you guys can take a seat.
Okay.
I've prepared a decision that I'll read into the record, and then I have copies for the parties.
Thank you, Judge.
Okay. And as far as the exhibits, let me turn these over to the clerk to maintain those. I think that should be all of them. All right. The matter before the court for decision following the bench trial held on January 26, 2023. It is hereby ordered as follows. The defendant is charged by information in 21 CM 81 with the offenses of resisting a peace officer, criminal trespass to real property, and disorderly conduct. The court had the opportunity to hear from the following witnesses at trial. U.S. Postal Inspector Daniel Rodriguez, Deputy Chief Matthew Wallace, Sergeant Shane Poole, now Annette Turk, Beverly Wigginton, T.W., Stephanie Johnson, Kayla Osborne, Detective K.C. Brox, Detective Ethan Barillo, and Richard Wigginton. As to the findings of fact, the court heard the following testimony in summary. First, as to Dan Rodriguez, he's a physical security specialist with the U.S. Postal Inspector Service. He testified that on May 18, 2021, he pulled video in reference to this incident and made a copy on a thumb drive, and he sent the video to the Belvedere Police Department. He identified People's Exhibit 1, a disc with post office surveillance, which accurately captured the incident, and it was not altered in any way. Deputy Chief Matthew Wallace of the Belvedere Police Department requested a copy of surveillance video, People's Exhibit 1, and placed it into evidence. Sergeant Shane Poole, now of the Belvedere Police Department, met with the defendant on July 7, 2021, at the Public Safety Building. The defendant turned in some paperwork as well as 2 DVDs in a white envelope. People's Exhibits 2 and 3 were identified as the disc placed into evidence. Annette Turk has worked for the Postal Service for 36 years and works at a Belvedere, Illinois post office. On May 18, 2021, she had an incident with a customer who would not leave. She spoke with Beverly Wigginton, who had a P.O. box and made complaints about having to wear a mask inside. She noted at least 3 complaints at various times. On May 18, 2021, Beverly came into the post office with a teenager. Beverly came in and dropped off a box for shipping. Annette advised Beverly of the mask policy. Beverly then asked to speak to a supervisor and proceeded to wait by the P.O. boxes. The teenager went outside and came back in with the defendant. Annette observed the defendant recording with his phone. She asked him to put it down to protect the privacy of the customers near the counter. At that time, staff was instructed not to allow video recording inside. Initially, the defendant was on the other side of the island, closer to the door. He was asking Beverly to find Poster 7, which advises when and where one can video record inside the post office. The defendant then came toward the counter saying they were going to be educated. Annette testified this made her feel uncomfortable and threatened. She further stated that the defendant was disrupting her interactions with the customers. She called her supervisor, Stephanie, who then came out. Stephanie reiterated the mask policy and asked him to leave. She then saw the defendant walking around the post office while continuing to record video on his phone. On cross-examination, Annette testified that the defendant never went anywhere that wasn't public. She felt threatened because she didn't know what the defendant meant by "get educated." While the defendant never physically got in anyone's way, he was speaking to employees and customers, disrupting her ability to conduct customer transactions. Beverly Wigginton is the defendant's wife. On May 18, 2021, she and her daughter went to the post office where she video recorded her interactions with post office employees. At one point, she told the defendant to be quiet. She stated that she told the defendant to be quiet because the defendant was talking over her while they were speaking with an employee. While waiting to see if the police were going to respond, she stated to the defendant, quote, "Is she calling or are we just wasting our time?" TW is the defendant's minor daughter. On May 18, 2021, she went into the post office with her mom while her dad waited in the car. Eventually, she went to the door and waved for the defendant to come in because the post office employee told them they had to wear masks. The defendant told her if the police come, he'd give her the phone and to not give her name. During the defendant's interactions with officers outside, he did give W the phone and she continued to record. She testified that this was not a First Amendment audit, but rather her and her mom just going to the post office to conduct business. Stephanie Johnson is the customer service supervisor at the Belvedere Post Office. On May 18, 2021, just before noon, she was back in her office. A clerk came and got her because a customer was not wearing a mask. She advised the defendant that he can't video record in the post office and that he has to wear a mask. She observed the defendant video recording with his phone and being loud while walking around the post office. Stephanie described the defendant's actions as loud and pushy. This made her feel as though he was being aggressive and confrontational. Stephanie told the defendant she was going to call the police, and he said, quote, "Please do." She stated that she felt threatened. This led her to go in the back and call the postal inspector, Russell Hale. She had not called the police. She testified that she further felt threatened when the defendant stated, quote, "Go ahead, you're about to get educated," in response to her saying she was going to call the police. Stephanie explained the distance she was behind the counter to the defendant using red tape on the counter in the courtroom, and the court estimates this to be around 10 feet. Stephanie advised that she wasn't refusing his business, just that they need to wear a mask. Toward the end of their interaction, she asked them to leave. On cross-examination, Stephanie testified that she advised the defendant he could not video record because it was the policy as she understood it at the time. Her understanding now is that people can record in public areas, just not where transactions are done. She didn't know what the defendant meant by, quote, "You're about to get educated," and at all times the defendant was in a public area. Kayla Osborne was a customer service supervisor with the Belvedere Post Office on May 18, 2021. At some point that day, Stephanie Johnson asked her to come up front due to a customer who didn't want to wear a mask. She observed a customer, later identified as the defendant, recording and walking around. She described him as aggravated. Kayla advised the defendant she was going to call the police. He responded negatively. He was approximately 15 feet away from her. He then came closer to record something on the wall, which made her feel nervous. She then went in the back to tell Stephanie. She called the police and then went back to the lobby. When the defendant got within 1 to 2 feet of her, it made her feel nervous. The police arrived and asked her if she wanted the defendant removed. She responded that she did. Kayla admitted that prior to the police arriving, she did not personally ask the defendant to leave. She believes Stephanie did ask him to leave. The defendant was confrontational, which made her feel nervous. At the time, she believed post office policy prohibited recording inside the post office. The policy now is to not do anything if someone is recording. Kyla testified that to her the defendant's behavior was bizarre. She explained that it was alarming and scary when the defendant was approaching her. Detective Brox was an officer with the Belvedere Police Department on May 18, 2021. On that date, she responded to the post office around 11:53 a.m. in reference to a disorderly subject refusing to leave. When she arrived, she went to the lobby and saw a male later identified as the defendant hold his phone up. She told him to get out. He did not immediately leave. After some arguing, the defendant did leave the lobby but did not leave the property. She advised the defendant that if he did not leave, he would be under arrest. He did not leave. Thereafter, she advised the defendant he was under arrest and went to take his left wrist. Officer Reese went to take his right wrist. The defendant tensed up and would not comply. The defendant pulled his right arm away from Officer Reese, and they ended up on the ground. Eventually, the defendant was handcuffed and arrested. The video from the defendant's phone was published in open court. Detective Brox indicated that the footage outside was edited. There is a gap from the time officers were placing the defendant's hands behind his back to when he ended up on the ground. People's Exhibit 1B, the footage from Camera 7 inside the post office, shows the unedited version of the arrest. Detective Brox stated that the defendant was pulling away when they tried to take him into custody. Detective Ethan Barillo of the Belvedere Police Department was assisting officers at the Belvedere Post Office on May 18, 2021. When he arrived, Detective Brox was inside. When he went to investigate, Detective Brox was walking outside with the defendant. He observed that Detective Brox was going to arrest the defendant and saw him break his break free. His arm, and the defendant testified that he was at the post office with his wife and daughter. He came in because his daughter called him to come inside due to a problem. He did not go there with the intention of filming that day. Once it was clear there was a dispute over masks, he began recording. He believes the building to be a public building, and that recording was allowed. He didn't go anywhere in the post office that wasn't public. His comments about educating the employee was made in a non-threatening way. The defendant stated that the employee didn't seem scared or threatened. He estimated she was about 20 feet way behind the counter. The defendant waited once he learned the police were coming. Initially, Detective Brox showed up. He was attempting to talk to her, but she kept saying, "Get out." Detective Brox never said that he was under arrest, and she made contact with him. Detective Brox grabbed his arm. He tried to give his phone to his daughter. They didn't give him any directives. The next thing he knows, he's on the ground. He stated that he had no intent to resist. On cross-examination, the defendant admitted that when Detective Brox asked the defendant to leave, he was attempting to get the officer's badge numbers. He also indicated he was recording the issue with masks that post on the internet as a freelancer. Now, as to count 1 resisting a peace. Officer, that count alleges Richard Wigginton committed the offense of resisting a peace officer, in that the said defendant knowing Officer K.C. Brox to be a peace officer engaged in an authorized act within her official duties, being the arrest of the defendant, pulled away from Officer Brox. A person commits the offense of resisting or obstructing a peace officer when he knowingly resists or obstructs the performance of any authorized act within his official capacity of one known to him to be a peace officer. That's citing IPI Criminal 22.13 as well as 720 ILCS 5 EA 31.1. To sustain the charge of resisting or obstructing a peace officer, the state must prove the following propositions. First, that K.C. Brox was a peace officer, and second, that the defendant knew K.C. Brox was a peace officer, and third, that the defendant knowingly resisted or obstructed the performance of an authorized act within his official capacity. On May 18, 2021, there is no dispute that K.C. Brox was a peace officer with the City of Belvedere Police Department. There's also no dispute that the defendant knew K.C. Brox was a police officer. The issue, therefore, is whether the defendant resisted or obstructed K.C. Brox of an authorized act. His arrest. Section 31.1 prohibits the resistance of a peace officer's performance of an authorized act and resistance has been defined as, quote, withstanding the force or effect of, or the exertion of oneself to counteract or defeat, and that's citing People versus Crawford, 152 ill, App 3D 992. It's a 4th District case from 1987. The statute prescribes only some physical act which imposes an obstacle which may impede, hinder, interrupt, prevent, or delay the performance of the officer's duties, also citing Crawford. Detective Brox testified that she advised the defendant he was under arrest and went to take hold of his wrist. She stated that he pulled away from her. The court has considered all of the testimony and evidence and finds Detective Brox's testimony to be credible. The court has also reviewed the exhibits that have been admitted into evidence. In the video, Detective Brox clearly states, quote, "That's it. You're going to jail right now," unquote. After hearing this, it is equally clear a person in the defendant's position would reasonably believe he was under arrest. The act of pulling away from Detective Brox is a physical act of resistance, which hindered or delayed the performance of Detective Brox's duties. The court finds that the state has proven beyond a reasonable doubt the offense of resisting a peace officer in Count 1. As to Count 2, it's alleged Richard Wigginton committed the offense of resisting a peace officer in that said defendant knowing Officer Zachary Reese to be a peace officer engaged in an authorized act within his official duties, being the arrest of the defendant pulled away from Officer Reese. The court, again, is considering all of the testimony and evidence presented and reasonable inferences to be drawn. Detective Brox testified that Officer Reese attempted to take a hold of the defendant's right wrist, and the defendant pulled away. As was the case in Count 1, this portion of the interaction is observable from footage inside the post office. In the video outside the post office, Reese is clearly identifiable as a police officer in full police uniform. Officer Reese attempted to grab onto defendant's wrist after Detective Brox advised that he was going to jail, i.e. under arrest. The court finds that the state has proven the defendant guilty beyond a reasonable doubt of the offense of resisting a peace officer. Count 2. Count 3 alleges Richard Wigginton committed the offense of resisting a peace officer in that said defendant knowing Officer Casey Brox to be a peace officer engaged in an authorized act within her official duties, being the arrest of the defendant, tensed his arms into a straight position when told to place his hands behind his back. The court had the opportunity to review People's Exhibit 3A, which was a recording of the defendant's arrest that begins once he is on the ground. Once on the ground, officers appear to have no trouble maneuvering the defendant's arms behind his back and handcuffing him. To the extent that the defendant's arms go tense, this is likely a natural physiological reaction. In any case, the court did not observe an act that impeded or prevented the officers from handcuffing the defendant. Therefore, the court finds that the state has not proven the defendant guilty beyond a reasonable doubt of the offense of resisting a peace officer. Count 3. Count 4 alleges Richard Wigginton committed the offense of criminal trespass to real property in that said defendant knowingly remained within the post office building at 1800 Belvedere, Illinois after being told by post office employees to leave the building. A person commits the offense of criminal trespass to real property when he knowingly remains upon the land or in a building other than a residence of another after receiving notice from the owner or occupant to depart, citing IPI Criminal 16.11 and 720 ILCF 5. P21301. A person has received notice from the owner or occupant, if he has been notified personally, either orally or in writing, citing IPI Criminal 16.11a. To sustain the charge of criminal trespass to real property, the state must prove the following propositions. First, that the defendant knowingly remained in a building other than a residence of another after receiving notice from the owner or occupant to depart, citing IPI Criminal 16.12a. The court has considered all of the evidence and testimony presented. In reviewing People's Exhibit 2A, It is not until Detective Brox arrives that the defendant is explicitly told to leave. Much of the time prior to police arrival was spent arguing over the mask policy and whether the defendant has any business there. The court finds that it wasn't until Detective Brox advised the defendant that he must leave that he was given, quote-unquote, notice. After Detective Brox confirms with Kyla Osborne that she wants him trespassed, she advises the defendant to leave. Shortly thereafter, he does exit the building. The court, therefore, finds that the state has not proven the defendant guilty of Count 4, criminal trespass to real property. Count 5 alleges Richard Wigginton committed the offense of criminal trespass to real property and that the said defendant knowingly remained on the land of the post office at 1800 Doc Wolf Drive, Belvedere, Illinois, after being told by Officer K. C. Brox, acting at the direction of a postal employee, Kyla Osborne, to leave the land. As explained above, Detective Brox advised the defendant while inside the post office that he's being trespassed and he must leave, while outside the building but still on post office property. She repeated this request. Detective Brox stated, quote, "I will remove you if you do not leave the property now," unquote. At this point, the defendant made an overt move back towards the building, explained that he wanted names and badge numbers. Despite the defendant stating he was leaving, his actions demonstrated otherwise. The court finds that the state has proven the defendant guilty of the offense of criminal trespass to real property, Count 5. Count 6 alleges Richard Wigginton committed the offense of disorderly conduct, and that said defendant knowingly acted in such an unreasonable manner as to alarm and disturb postal employee Stephanie Johnson and to provoke a breach of the peace, and that said defendant continued to video record. Employees and patrons of the post office after being told to stop recording by Stephanie Johnson. A person commits the offense of disorderly conduct when he knowingly does any act in such an unreasonable manner as to alarm and disturb another and to provoke a breach of the peace. Citing Illinois Pattern Instruction Criminal No. 19.7 and 720 ILCS 5 A26-1. In this case, the state must prove beyond a reasonable doubt the following propositions. First, that the defendant knowingly performed an act in such an unreasonable manner as to alarm or disturb another and provoke a breach of the peace. Citing IPI Criminal No. 19.8. As a threshold matter, in order to sustain the charge of disorderly conduct, the trier of fact must first find that the state has proven beyond a reasonable doubt that the defendant knowingly acted in such an unreasonable manner. The purpose of the disorderly conduct statute is to protect against an invasion of the rights of others, not to be molested or harassed either mentally or physically without justification. And that's citing People versus Pence, 2018 ILAP 2D 151,102 at paragraph 17, which is citing People versus Davis, an Illinois Supreme Court case from 1980. It was a highly fact-specific inquiry. It embraces a wide variety of conduct serving to destroy the public order and tranquility, citing People versus McLennan, 2011 ILAP 2D 91,299 at paragraph 30. A culpability revolves not only around the type of conduct, but is equally dependent upon the surrounding circumstances, and that's citing the Davis case. The court is also considering the First Amendment argument advanced by the defense, to wit, that the protected activities cannot be deemed unreasonable. The First Amendment right is a fundamental right protected from invasion by the state by the 14th Amendment. Citing People versus Redwood, 335 IL, App 3D 189 at page 192. That's an Illinois Supreme Court case from 2002. Because of that right, the government lacks power to limit expression based on its ideas, message, subject matter, or content. Citing People versus Relaford, 2017 IL 121,094. The right of free speech is not, however, absolute at all times and under all circumstances. Citing Chaplinsky v. New Hampshire, U.S. Supreme Court case from 1942. There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. Also citing Chaplinsky v. New Hampshire. These include the lewd and obscene, the profane, the libelous, and the insulting or, quote-unquote, fighting words, those by which their very utterance inflict injury or incite an immediate breach of the peace, also citing Chaplinsky. Here, the defense is not making a facial challenge to the disorderly conduct statute or any governmental content-based speech restriction. Rather, the defense is raising an as-applied challenge. In essence, the defense argues that the acts attributed to the defendant in the charges for disorderly conduct are protected by the First Amendment. A party asserting an as-applied challenge under the First Amendment bears the burden of showing the statutes that are the basis of his convictions that were unconstitutionally applied to him. That's citing People v. Rollins, 2021 Ill, App. 2D 181,040 at paragraph 15. Applying these standards to the instant case, the court does not find that the disorderly conduct statute is unconstitutionally applied to the defendant. As always, the court must consider the specific facts of the case. While in some instances, the act of recording in a public place may be constitutionally protected, the court must consider these specific facts in this case. Therefore, the court rejects the argument that the act of video recording in a post office cannot be deemed unreasonable. In this case, Stephanie Johnson asked the defendant to stop recording and put a mask on. A disagreement ensued over the mask policy. The court reviewed People's Exhibit 2A multiple times. While the defendant was antagonistic, he didn't yell, raise his voice, or make any threatening statements towards Stephanie Johnson. Also, Stephanie Johnson remained calm and polite in her interactions with the defendant. The court is considering the facts specific to this case in determining whether the alleged acts attributed to the defendant were unreasonable. At the point of his interaction with Stephanie Johnson, the defendant's wife had concluded the purpose of her visit. The defendant's only reason for still being inside the post office at this point was to argue with employees over their mask policy. The court finds the actions of the defendant to continue to record employees and patrons inside the post office after being told to stop was unreasonable. To support the charge of disorderly conduct, not only must the person act unreasonably, their actions must alarm and disturb another. As noted above, Stephanie Johnson remained calm in her interactions with the defendant. At all times, the defendant remained in the public area. He didn't make any specific threats or raise his voice. Clearly, she was annoyed by the defendant's behavior. It stands to reason that she may have even been concerned about the possibility of things escalating, but that is not enough. Therefore, the court finds that state has not proved beyond a reasonable doubt the offense of disorderly conduct. Count 6, Count 7 alleges Richard Wigginton committed the offense of disorderly conduct and that said defendant knowingly acted in such an unreasonable manner as to alarm and disturb postal employee Stephanie Johnson and to provoke a breach of the peace, and that said defendant acted in a threatening manner and said to Stephanie Johnson, quote, "You want to get educated today," after being told by Stephanie Johnson that she was calling the police. The court must consider the surrounding circumstances in determining whether the defendant's actions were unreasonable and whether they alarmed and disturbed Stephanie Johnson. The court notes in its review of People's Exhibit 2A that the defendant's statement, quote, "You want to get educated today," is part of the overall conversation regarding the mask policy and video recording. Threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals, citing Virginia versus Black, 538 U.S. 343 at page 359, a 2003 U.S. Supreme Court case. The court does not perceive the defendant's statement to Stephanie Johnson as a threat. Rather, was part of his overall aim to, quote-unquote, educate the Belvedere post office employees on this particular day. The court does not deem this statement to be unreasonable as contemplated in the disorderly conduct statute. Therefore, the court finds the state has not proven the defendant guilty beyond a reasonable doubt of the offense of disorderly conduct. Count 7. Count 8. 8 alleges Richard Wigginton committed the offense of disorderly conduct in that said defendant knowingly acted in such an unreasonable manner as to alarm and disturb postal employees and to provoke a breach of the peace in that said defendant followed and approached employees and disrupted their interactions with patrons at the post office. As stated above, the court has determined that the defendant's actions of walking around the post office, video recording, antagonizing postal employees, and recording while customers were engaging in transactions were unreasonable. The court is considering the testimonies of Annette Turk and Kyla Osborne, as well as the video recordings admitted into evidence. While the defendant remains in public areas at all times, and while he mills about the lobby and over near the P.O. boxes, he also comes near the counter while other patrons are conducting business. This is well after Beverly has finished her stated business with the post office. The defendant's only reason for staying at this point is to argue with employees and record his interactions, presumably all with the intention of posting this on the internet. Annette Turk testified that she felt uncomfortable and threatened. The defendant was repeatedly engaging with customers, which was disrupting her ability to perform her job. When Kyla Osborne came out and advised the defendant she was calling the police, the defendant approached her, which made her feel nervous. She later testified she was alarmed and concerned by the defendant's behavior and that it was scary. The court finds that postal employees were alarmed and disturbed by the defendant's behavior. Disorderly conduct is a highly fact-specific inquiry that embraces a wide variety of conduct serving to destroy or menace the public order and tranquility. Citing in ReBC, a 1997 Illinois Supreme Court case. Generally, a defendant's conduct must threaten another or affect the surrounding crowd to breach the peace. Citing in ReDW Illinois Supreme Court case from 1986. However, a breach of the peace can occur without overt threats or profane and abusive language. Citing People versus Divine 2022. Ill. App. 2D. 210,162. At paragraph 43. The actions of the defendant, in this case, caused the disruption in the operations of the post office. The defendant spent a number of minutes walking around the post office, engaging customers and post office employees, arguing about the mask policy, and continuing to record near the area where customers were conducting transactions. 2 separate supervisors asked the defendant to stop, seeing as he had no further business with them. The defendant's sole motivation was to poke and prod and antagonize post office employees for enforcing their mask policy. These actions did destroy or menace the public order and tranquility. Citing in ReBC, they did provoke a breach of the peace. Therefore, the court finds the state has proved beyond a reasonable doubt the offense of disorderly conduct. Count 8. It is, therefore, ordered that the defendant, Richard Wigginton, is found guilty of the offense of resisting a peace officer, counts 1 and 2. Not guilty of resisting a peace officer, count 3. Not guilty of the offense of criminal trespass to real property, count 4. Guilty of criminal trespass to real property, count 5. Not guilty of the offense of disorderly conduct, counts 6 and 7. Guilty of the offense of disorderly conduct, count 8. All right. See order. I've got copies for both counsels. All right. And at this time, based on statute, the court will enter judgments as to counts 1 and 2, 5, and count 7. Are the parties prepared to proceed to sentencing now?
Yes, Judge.
Yes, Your Honor.
Okay, all right. The court has considered first arguments of state in support of the factors in aggravation. 730 ILCS 5553.2. I understand the state's point as to whether this threatened or caused or threatened serious harm. Notwithstanding the findings and what could have happened, I don't think Mr. Wigginton went to the post office that day, or at least went into the post office from the time he started recording to threaten harm or cause harm. Certainly, physical acts of resistance or non-compliance with officers' directives have the serious potential to cause either harm to himself or to the officers or public bystanders, but for purposes of factors in aggravation, I don't know that that particular subsection was contemplated as opposed to, let's say, crimes of violence, like a battery or aggravated battery or discharge of a firearm. I will find in this particular instance, notwithstanding the escalation of everything that Mr. Wigginton's conduct caused or threatened serious harm. Mr. Wigginton doesn't have a serious history of criminal activity. I do believe that the sentence is necessary to deter others from committing the same crime or engaging in the same conduct. I'm also considering Mr. Wigginton's age, his physical traits, ties to the community. I'll find in mitigation that the defendant's conduct neither caused nor threatened serious physical harm to another, nor did Mr. Wigginton contemplate that his conduct would cause or threaten serious physical harm to another. I think his intention, my inference based on everything is as was testified to, that at that point in time in May of 2021, certain restrictions vis-a-vis the mask policy had been lifted in some areas. Federal employees were following their own policy, their belief mistaken or otherwise, as to the policy and whether you could record inside the post office. I think Mr. Wigginton's intention by recording was to play some sort of gotcha and post it to the internet. It seems to be the case. I don't find that he acted under a strong provocation or that there were substantial grounds tending to excuse or justify his conduct or that it was facilitated by someone else. There's no compensation or at least financial compensation to anybody. Again, I find he has lack of any criminal history. I can't find that the conduct was a result of circumstances unlikely to recur or that character and attitudes of Mr. Wigginton indicate that he's unlikely to commit similar acts, but I do think that judgments of conviction and the following sentence are necessary under these specific circumstances and to deter others. I'll find an aggravation. So, judgments of conviction will enter as to count 1, 2, 5, and 8. I'll sentence Mr. Wigginton to 10 days Boone County Jail. Day for day to apply. Credit for 1 day served, so that's going to leave a balance they're asking, and we can stay if you want to consult with Mr. Wigginton as to a turn and date.
He's ready to go in today.
Today. Okay, all right.
He'll just have 4 more to serve, Your Honor.
And then he'll be released at 6:00 a.m., I believe on the 4th day.
Yes.
So, today's the 1st, so today I have to look at a calendar. 4 days. Yeah, today, tomorrow. So, I believe he'd be released Saturday morning. And then fines, fees, and assessments. I'll authorize the standard assessment for class and misdemeanor and then statutory fines and fees. I'm not sure what that amounts to.
Your Honor, do you want that on each count or on just one?
It can just be one.
Okay, so one, I don't know that there's actually a statutory requirement for the amount. Generally, it's $100 for the fine.
Okay, $100 fine, and then whatever I think it's $449 is the assessment, if I'm not mistaken.
Yes.
I don't believe there was any bond posted.
$70, Your Honor.
Oh, okay, that can apply.
And then he gets the $30 credit.
And then the $30 per diem will go towards that. The balance can go on a payment plan of at least $25 a month starting on or before April 18. Mr. Wigginton is free to pay that sooner if he wishes. Have I left anything out?
I don't think so, Your Honor.
I don't think so.
Okay. We'll prepare then in just a second for you to review, and for Mr. Wigginton.
And Judge, just a question about the protective order from the post office, because they still do have business to conduct, and this would be like a no illegal conduct type of...
You mean is no contact a condition of bond?
Correct.
So, I'm simply entering.
As far as the bond, so yeah.
Okay, so once I enter judgment, once this is concluded, there's no more bond, quote unquote.
Okay.
So that won't be a court condition. I have no idea if the post office still considers him trespassed or what their take is. I would certainly inquire into that before he goes back.
Your Honor, I think the question may be, too, about the protective order for the record.
And for the record, yes.
I believe that remains in effect until...
I believe so until further order of the court.
Right, because those are still court records of the proceedings, if you will. I think that's in perpetuity until there's some modification.
Okay.
Any other questions?
No.
All right, we'll have him sign that, and then I'll advise Mr. Wigginton of his appeal rights. And has Mr. Wigginton signed this?
He did.
Any questions about this?
Your Honor, if you could just check the counts to make sure I got those correct, please.
Sure. Yep.
Okay. Thank you.
All right, Mr. Wigginton, I'm going to go ahead and sign these orders. That concludes everything. You do have a notice to appeal. If you did wish to appeal from this, you'd have to file within 30 days of today's date a written notice of appeal. Any basis for your appeal must be in writing, otherwise, it's waived or given up. If you are indigent, a copy of the transcripts of the proceedings could be provided to you without cost, and an attorney could be appointed to assist you with the preparation of those motions. Do you understand that?
Yes, Your Honor.
Okay, very good. All right. I'd like to thank everyone for presentation of the case, and then we'll scan these in. Counsel, if you want to get copies of these downstairs at the clerk's office.
Sounds good. Thank you, Your Honor.
And, all right. I believe that's it. Thank you, everyone.
Case concluded at 2:27 p.m.